It's Entertainment Law Update, episode 167 for, well, it's May 1st, 2024. Here we go. Hello, everybody, and welcome back to another episode of Entertainment Law Update from Los Angeles, California. I am Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamera Bennett.
And this is our podcast about entertainment law, where each month we pull together a roundup of legal and business news stories and share our opinions and commentary and analysis and chit-chat and try to have a good time with it all. And here we are. How are you today, Tamara?
I am doing great. I'm just giving the heads up that my allergies are like wild and crazy. So I'm drugged up. Maybe that's what I'm saying.
Woohoo, time to party.
If for some reason my screen goes blank, I don't know. Maybe I had to leave the building for my allergies, or I'm sneezing. That could be it.
So, that could, okay.
Yeah, just giving everybody a heads up on that if I disappear.
All right. Well, things here in LA are good too. No complaints. The weather is starting to warm up and the insects are starting to show up again and all that kind of fun. But everybody's good, so glad to be here.
Do you guys get cicadas?
We do not get cicadas here in the desert.
Okay, just checking.
But mosquitoes and crane flies are a thing here. Crane flies, these giant. They look like a mosquito, but they're about 1.5 inches big.
Oh yeah, we call them mayflies.
Yeah, and they're all over the place. So anyway, so much. This is not a show about what is it called? Study of insects.
I don't know.
Outside
it's not
my
the
area,
study of insect or wild kingdom.
Yeah.
So.
Anyway, well, we thank you, our listeners, for being here with us and tolerating our attempts at chit chat. And we'll just tell you about our sponsor for this episode. We are brought to you this episode, as many, by JD Supra, a leading platform in professional services content marketing, where they help lawyers turn their expertise into networking opportunities, media visibility, and new business. JD Supra publishes and distributes blog posts, articles, podcasts, videos, and other thought leadership to hundreds of thousands of subscribers on a daily basis, including business leaders, in-house counsel, media members, the C-suite, and others who have a need-to-know interest in legal, regulatory, and compliance matters. JD Supra clients not only enjoy wide readership of their thought leadership, and they're also provided with the data and the tools to turn that visibility into marketing and business development success. More information at resources.jdsupra.com. And we have a busy episode for you today. We are going to talk about a couple of big cases, and we have a lot on the AI front. So I'm calling this episode, Is It Real, or is it live, or is it something else? So let's just start with it's medium big news, I guess you could say. We talked about it a year ago when the case broke, the Top Gun Maverick situation. And there's been a motion for summary judgment granted in favor of Paramount Pictures in this case, brought by the widow of Ehud Yonah, the writer of the article Top Gun back in 1983, that detailed the experiences of F-14 pilots and their radio intercept officers during their training, that Paramount Pictures had purchased an option, or they bought the rights to that article, and then they made the original movie Top Gun that was suggested by Yonah's article. The original film featured fictional characters at the Naval Fighter Weapons School that was depicted in the article by Yonah as well. So 2018 rolls around, and the plaintiffs had sent a notice of termination of the grant of copyright transfer rights. That was effective January 24th, 2020. And then the Maverick movie, the sequel to Top Gun, was released in 2022 or so, without giving Yonah any credit at all. Now, the Top Gun Maverick movie was set 30 years later, after the original Top Gun, where the the lead character, Maverick, was now a test pilot training a class of graduates. And the court had to grapple with sort of two issues. The big one was whether there was copyright infringement, and also there was a breach of contract claim. So on copyright infringement, the only dispute was whether or not the Top Gun Maverick had striking similarity or substantial similarity with the original article. And the court decided not really. They said the article itself was a nonfiction work that detailed how a pilot and his radio intercept officer were shot down by their instructor, and the caste system and history of the school and the intense nature of the training, all of which was depicted in the film. But the original film was a work of fiction with those fictional characters, and now the sequel film was also a work of fiction, starting with the character of Maverick disobeying orders, getting reprimanded, and then having to train a group of graduates on a important mission. And there was drama about the relationship between Maverick and his former Rio's son, who was now a naval aviator. And ultimately, the court looked at it and said, look, the school, the Naval Aviator School Top Gun, is a real fighter pilot school, and the factual elements embodied in the story are not protected under copyright law. And the general plot ideas were not protected as well. And then the court moved on to the breach of contract analysis, saying there was no breach of contract because the production occurred after the termination of those motion picture rights. So there was no longer a contract in force, essentially. The film was not produced under that assignment of any rights. The movie came out following the termination. And there was language in the contract that said, in the original agreement, that made it clear that nothing in that agreement would prevent a party from doing anything that any member of the public could do. So in theory, a studio like Universal, a different production company, could put out another movie about the Top Gun Naval Aviator Training School, and that wouldn't infringe any rights. So Paramount could do the same thing. And so summary judgment granted in favor of Paramount. As yet, we haven't seen whether there's an appeal of anything, but looks like Paramount's off the hook on this one.
So I thought it was interesting. The court talked about that the article back to the 80s was written in a non-linear fashion from a time perspective.
Oh, interesting.
Forwards and backwards, different again about different real people and the time. So the timeline didn't go in a linear fashion, but that Maverick Top Gun is in a linear fashion. And that was one of the things that obviously the defense argued that to distinguish that substantial similarity. I really thought it was, I guess, two thoughts on these statements about the termination and there being no contract. So evidently the studio is not fighting the copyright grant termination because they determined it probably didn't give them the rights they got out of that article, probably weren't helpful anymore.
Well, I think at the time it was in the early 80s, the decision to option the article may have been just sort of keep it out of the hands of everybody else and sort of lay claim to that name Top Gun, even though that's what the school is called. They may have not needed them even back in the 80s, except that it was more expedient to do that to get the rights and frankly, maybe the right thing to do. Hey, we read your article. We loved it. It inspired us to make this movie. Let's make a deal. But the sequel is based on the original movie, not on his article. And I think that's what the court came to.
Yeah. I mean, it's interesting because clearly Top Gun Maverick is a derivative of the first movie, but what the court is making the decision on is that it's not Top Gun Maverick is not a derivative of the article.
Yes, I think that's an accurate way of articulating it. So good news for the lovers of the Paramount films, and not so wonderful for the family of Yone, but I think it's the right decision in this particular instance. So.
And I believe there's talk that there's a third.
Oh.
Third in the series.
I haven't heard that. I'm a fan. I'll look forward to that.
Yeah, I know. I am too.
Okay, well, we mentioned we've got a lot to talk about, and we've got a lot on the AI topic today. So we're going to just jump right into AI and talk about your home state,
Okay.
Tennessee, and the Elvis Act. Do you want to take this story?
Sure. So, and I've actually been doing some back and forth between here and Tennessee. So I
Hmm.
was in Nashville when this passed. So it was some exciting news all over the news in the Nashville with the music business. But anyway, Tennessee just passed a new bill titled the Elvis Act, short of ensuring likeness, voice, and image security Act of 2024. It amends their prior state right of publicity law. As we've talked about a bunch of times, right of publicity is not a federal right, it is a state by state. So it amends their 1984 Act, and it takes effect on July 1st, 2024. The Elvis Act establishes strong protections related to individual voice, image, and likeness against unauthorized artificial intelligence derived from deep fakes and voice clones. Kind of the summary of the main changes is adding a person's voice to the scope of right of publicity protection in Tennessee. I thought that was interesting with it being Music City, USA, that
Yeah.
that wasn't in there. But definition of voice adds protection to simulation of an individual's voice, which means simulated or AI generated replica of another
Hmm.
individual will be protected. So it can be a sound in a medium that is, quote, readily identifiable and attributable to a particular individual, regardless of whether the sound contains the actual voice or simulation of the voice of that individual. Gives broader protection against unauthorized use of a voice likeness as long as it is for purposes of advertising without the use being an item of commerce. So, purpose of advertising products, merchandise, goods, or services is the amendment to the act, or for
Yeah.
purposes of fundraising, soliciting donations, anything you're trying to sell something or make money from, as well as giving a civil action ability for violation of this act, and a new cause of action as well when someone creates an AI model or platform for users to create AI generated photo, voice, or likeness with the knowledge that it will violate the act. So, not only an individual right, but also a cause of action to go against these platforms that, I don't know, maybe this will help broaden the act
Yeah,
to pursue
I
claims.
have some concerns about that part because you're essentially saying, you look, you made the software, you're liable, and that sort of gets us into the Sony Betamax analysis. And,
Mm-hmm.
does it have other legitimate uses? But I guess that knowledge component may be the workaround there.
Maybe. It also adds a section specifically for recording artists where they are allowed to sue over commercial use of their voice,
Hmm.
and giving some rights if they've assigned that right to a record label where a
Hmm.
person has entered into a contract for an individual's exclusive personal services as a recording artist, or an exclusive license to distribute sound recordings that capture an individual's audio performance. An action to enforce that right set for it may be brought by the person or the individual.
Hmm.
And there's some exemptions for news, public affairs, sports broadcasting, that's listed in the present law. The new bill adds a list of exemptions to the extent that such rights are protected by the First Amendment,
Hmm.
for comment, criticism, scholarship, satire, parody, or fleeting or incidental. So they're trying to carve out
Really
the
careful to get it into the commercial speech context where the
yeah.
First Amendment has some flexibility and these kinds of things.
So this is the first, to my knowledge, this is the first state law that's passed and is going to be enacted specifically addressing the AI concerns. We're going to talk about this whole section about a whole
Yeah.
lot of other things that are happening at the federal level or are trying to happen
Hmm.
at the federal level on AI and deep fakes.
Well,
So,
California's law does have the word voice in the right of publicity statute. So, but it doesn't say specifically simulated voice. But there is the case law about, Bette Midler and Tom Waits
right.
and that line of cases saying,
And Johnny Carson,
and Johnny
correct?
Carr. I think so. Yeah. Yeah.
Yeah, here's
So
Johnny.
just To be really clear, though, because I've heard some talk about chatter among folks about this, and just to be really clear, this would not prevent someone from doing like a parody video where they have
Mhm.
a simulated or audio, a simulated voice or something. There's that one of Johnny Cash singing "I'm a Barbie Girl."
Oh,
Um,
I've not heard that
oh
one.
yeah, if you haven't heard that, it's hilarious because it really sounds just like him, and you can find that on YouTube. There's actually a whole YouTube channel dedicated to. There's one of Simon and Garfunkel singing "I Like Big Butts," that kind of thing. So, but for humor and parody's sake, that still First Amendment protection is going to come into play. So this is really aimed at that commercial use, the kind of thing that essentially hurts the economic interests of the artist.
And so as we move through our conversation, I'd made a note, and I'll circle back to it as we get down into our stories
Hmm.
about how maybe some of these standards of parody, which is really the parody has to make fun of the original. So even if they're using Johnny Carson's AI
Hmm.
voice, is it truly a parody? You
Well, the
know,
question then becomes: it's a parody of what? Is it of Johnny Carson, or is it of the song, or the sketch that he was doing? I think both of those would qualify. But if they're just making fun of something else and making it sound like it was Johnny Carson doing it, probably not.
yeah, it's probably not. So
And that's
there's still in my mind always this fine line on
yeah.
when I talk to clients about what parody is and isn't.
Hmm.
Uh,
Yeah,
it's
so that's
not
going to
just
bring in this
changing the lyrics.
interesting
It's not just making funny lyrics to a
right.
country standard.
Right.
So
And that's a copyright analysis, but we would apply it, I think, to this um, right of publicity, First Amendment, maybe even some unfair competition kinds of
mm,
arguments in there as well. But parody is parody, and we've got, I think, pretty solid definitions from the Two Live Crew case and those kinds of things that do a pretty good job of articulating where the boundaries are for parody. So.
right.
Well, there's a federal statute in the works. The Generative AI Copyright Disclosure Act was introduced in the House on April 9th by California Representative Adam Schiff. The bill requires AI developers to send notice to copyright holders of any work that they've used in training an AI program. And that notice is to be sent at least 30 days before the AI program is made available to the public. So it's the AI, not the output, that we have to think about. The
Mhm.
proposed law would require that anyone who creates or alters a data set used for AI training to send a notice to the Register of Copyrights with a sufficiently detailed summary of any copyrighted works used. And that would essentially provide the owners of those copyrights, I guess, a chance to object and maybe opt out. Um, Currently, there are folks that are
Yeah.
looking for reparations for use of their works in training these tools, are facing uphill climbs in the courts. And so the supporters of this bill say this could be a step toward protecting artists, writers, creators of all sorts, and to provide for some model for compensation and less of this outright taking, I guess you could say. The House also has the No AI Fraud Act, which would effectively create a federal right of publicity, enabling individuals or rights holders to sue over unauthorized use of a person's likeness or voice. But this is the Generative AI Copyright Disclosure Act is more about um, uh, requiring some transparency. So there are two twin lawsuits also centering on this, what's described here as AI's shadowy copyright management. And that's taken from an approach in the case of the Intercept Media Inc. versus OpenAI and Raw Story Media versus Alternet. Oh, I'm sorry, also versus OpenAI. We covered that in last month's episode. In both of those cases, the plaintiffs argued that the AI took steps to conceal the copyright infringement by intentionally removing copyright management information, the authorship information, those kinds of things. And all of this sort of reflects the European Union's AI Act, which requires disclosure also of use of copyrighted materials and so on. So lots of backing from trade groups in the IP industries, music industry, the Human Artistry Campaign, SAG-AFTRA, so on and so forth, and the other entertainment industry unions. So we'll get some pushback for sure, and we'll be watching to see what happens in Congress. I think Congress has trouble, deciding what to have for lunch, much less what to do about the law these days. So
Oh, yeah, this may be a low priority for them.
exactly.
But who knows? Um, I think it's interesting. It feels a little bit like I told you, so I'm okay. I don't know. It's like almost this kind of notice for a compulsory license for a mechanical license. If
Yeah,
I give you the information, it's all going to be okay. I can't quite figure out how it gets us where we want to, how
I
it would get the content owners where they want to go.
I agree. I think all it does is open the door to maybe some earlier litigation asking for injunctions or something like that, but we still have to make a case for why it's not fair use, why it's infringement.
Why it's not acceptable to do that. I also wanted to bring up, we talked about this, I guess it would have been in the probably fourth quarter of 2023, which was
Hmm.
the Deep Fakes Accountability Act introduced in September
Yeah,
2023. And nothing has happened on that since the
right.
introduction. So it looks like we've got kind of pending is this generative AI copyright
Hmm.
disclosure and the House's No AI Fraud Act. And we'll see if anything else comes up at the federal level.
And here we are. It's an election year, and there are bigger fish to fry, and frankly more posturing to do on other hotter topics than all of this. So
Right.
I don't expect much to happen, and if it does, great, and we'll see. But I agree that the disclosure isn't really the issue. The prohibition on doing this without permission or consent is where we need to have um, more teeth in the law. I think, at least that's the argument that the copyright industries want. So
Right.
interesting that they're supporting it, but maybe it's better. Something's better than nothing. Kind of an approach there.
And I guess I know we had just added in some late breaking things on the
Yeah.
No Fakes Act, which
Hmm.
had Senate hearings yesterday. So that's
Yeah.
another, I guess, third prong to the component of what's happening at the federal level.
Yeah, yeah, we'll get to that story in a couple of minutes.
Yep.
Um, let's move on to this story about SAG-AFTRA and the record companies. They've reached this deal over AI in recordings. Back in early April, Billie Eilish had and another couple hundred musicians had signed an open letter for AI developers to respect the rights of artists and ensure that they get a fair deal from the AI generated music platforms and paradigms. And some of the world's largest record labels have now reached a tentative agreement with SAG-AFTRA covering the use of AI generated voice impersonation. And that's still waiting for the union to ratify the members to ratify the rule. Sony, Warner Music, Universal, and Disney have made a commitment to some consent and compensation requirements. It's interesting that it's SAG-AFTRA and not AFM and what is it, the AGVA, AGMA, all those other.
Well, right. AFM is Federation of Musicians,
Mhm.
and AFTRA covers the
Radio
recording
artists.
artists,
Yeah.
the
Okay.
actual vocal talent.
Yeah.
Uh, and they are, it is SAG-AFTRA. I
Yeah.
guess I
Yeah.
don't know how all the administration plays out, but I think they work together from an administrative
Yeah.
standpoint of
And their
royalties and
sister
collections.
unions with the other
It's
unions too.
sister
So
unions,
yeah.
yeah.
Yeah. Anyway, under the agreement, record labels would need this clear and conspicuous consent from copyright owners, interesting, covering minimum compensation requirements and specific details about how they intend to use any recordings. So that's on the ingestion side before the training of AIs and things. Pretty similar to what the studios agreed to. The movie studios agreed to with SAG-AFTRA last year. So um, the union is holding the line on that and doing a good job of it. It sounds like.
And some of what I had read that maybe this is voice talent for on the video film production side, that maybe they weren't so happy with what the union agreed to for them.
Hmm.
So if this is mirroring it, that's easy for me to
It
say.
yeah.
I'm going to dig in deeper as I'm concerned about how this plays out for my clients and also
Hmm.
making sure that the labels are honoring this.
Yeah, that'll be
in,
the
in
trick,
their
won't it?
in their artist deals for the voice talent.
Well, and meanwhile, we are hearing lots of stories about AI generated, deep fake audio recordings of artists who didn't actually collaborating, or who are now deceased, doing
That's right.
performances with living people and so on. So, yeah, it'll be interesting to see what those labels do, and the artists on those labels who have been trying to do this kind of thing. Well, we have another AI story here. The Czech courts have weighed in on the question of copyright protection for AI generated or AI assisted works. In this case, the plaintiff had generated an image using the program DALL-E. The prompt was create a visual representation of two parties signing a business contract in a formal setting, like a conference room or a law firm office in Prague, and show only their hands. So the plaintiff subsequently took this generated image, put it on a website, and then the defendant took it from the website, put it on their own website. And the plaintiff objected on the basis that they were the author of that generated image and demanded it be withdrawn and distribution be stopped without their consent, and took them to court. And the key issues were whether that image is even eligible for copyright protection, whether the person created the prompt based on the AI could be considered the author of that image for the purpose of copyright law. And the municipal court in Prague said no. Only a natural person can be the author of a copyrighted work. And since the AI is not a natural person, the AI can't be an author. It has to be the unique result of a creative activity of a natural person. And unless the creator can demonstrate that the generated image is the result of their unique creative contribution, it's not a work of authorship. So no copyright.
Yeah.
It is up on
That
appeal.
lines up with us. I
Yeah.
feel like,
I
and
think so
I
far it's just China and Vietnam that have said differently.
and I haven't. I don't remember the Vietnam. Did we
I
talk
heard
about?
something about that not long
Okay.
ago, that and it didn't go as far as China, but it was, basically saying, yeah, there are scenarios where the crafting of the prompt can be the act of authorship or something along those lines. So,
But then you still have this whole thing of, okay, so they've said that, but then how do I still enforce my rights if
right.
you're outside of, if you created something in the US that would then be infringed in China?
Yeah.
So probably doesn't help our folks too much.
Maybe it helps someone in China, but who's infringed here, but not the other way
Not
around.
the other way around.
Yeah.
Not the other way around.
Yeah.
So anyway, I jumped the gun on the third
Well,
prong of
let's
our
cover it.
AI legislation, but the No Fakes Act Senate Judiciary Committee hearings yesterday,
Mm-hmm.
I on April 30th, I plugged in a link to the C-SPAN video. I don't know how long C-SPAN leaves those videos up, but it's
Mm-hmm.
active for right now. If you want to go watch that 2-hour hearing and report back,
Yeah.
that'd be great. But FKA Twigs testified on April 30th before the Senate committee about the dangers of unauthorized use of AI to mimic an artist's style and personas. She herself developed a deep fake over the past year to explore using AI for marketing purposes and to get ahead of others who may want to misuse her likeness.
Mm-hmm.
Uh, Twig argued, sorry, Twiggy, I'm dating myself just a little bit. Sorry, no one under 50 is going to get that, but all of our
Right.
listeners and viewers over 50 will appreciate that. Twig argued that AI technology threatens artists' identities and livelihoods if their voices, images, and art can be replicated without their consent. She sees this as exploitation of creators during a major technology shift. Huh. That feels like every time that happens. Much like artists have been exploited in the past by innovations. Well, she continued with that. While acknowledging AI's creative potential if controlled by the artist, Twigs plans on urging the committee, or did urge the committee, her written statement was released ahead of the hearing, to enact regulations protecting individuals' artist work, their voices and likenesses from being co opted harmfully by AI without permission or compensation. And she frames this as a safeguard, not just for artists' rights, but the public's rights over their identities, in the future of AI landscape. So, the No Fakes Act, which is this third prong we're talking about, is proposed federal legislation aimed at protecting individuals from the unauthorized use of their voice, image, and likeness in digital replicas, including deepfakes and voice clones. It's also known as the Nurture Originals, Foster Art, and Keep Entertainment Safe Act, and it was introduced back in October of 2023, and we're just having some hearings here in end of April. So the goal is to create a federal right of publicity. And as we just discussed earlier, we don't have one of those. Everything is state by state. Some saying voice, image, and likeness. Some, as we've just learned, not mentioning voice. Some operable state laws during a person's lifetime. In Texas, the statutory right of publicity is effective after death, even though you can enforce some of those state rights through misappropriation. In Texas, we don't have an active right of publicity law during the artist's life. So I don't know. What do you got to add to that, Gordon? What do you think? So I can hear you see you animatedly discussing, but I can't hear you.
That's because I had to cough and I muted my microphone. So what I was
Oh,
saying,
so it wasn't my allergies,
no,
folks. It was
no.
Gordon's. He very animatedly responded to my prompt to jump
Well,
in.
it's nice that I had a rehearsal for what I'm about to say again now. I I was questioning, how does the federal government get into an area that has historically been a subject of state regulation? And I mean, I guess there are situations where Congress just decides, okay, it's time for us to occupy this field and either declare that this is a federal question kind of a thing, um, using what, the Commerce Clause, probably something like that. But I
I think it
challenge
has to
whether
be the Commerce Clause. I mean,
pretty,
if
yeah,
that's the whole how they can regulate trademarks is if they're in
yeah,
interstate commerce. So,
yeah. I don't see them declaring that suddenly this is part of copyright law or something like that, and
no.
therefore, has its own statutory or constitutional authority. But the real question is, does Congress even have the will to come in and do this? And does that send a message in other areas of law that are hot button issues around, uh, where the power of the states and the power of the federal government, the federalism question? So I don't hold a lot of hope that a federal law like this comes into play anytime soon, but I'm glad we're talking about it, and it's reaching the public stage in this way.
Right,
Um,
and crafting a complaint, you can use there are certain provisions of the
mm,
Trademark Act, Lanham Act that can be
yeah,
used sort of like a right of publicity uh, cause of action, as well as the state law causes of
hmm,
action. And maybe just because who the players are in this now, it gets more interest.
yeah,
And I would think the technology side would much rather get this addressed in one law versus potentially
yeah.
50
That's a
laws.
good point. That's a good point. So that lobby may actually step in and say, "Okay, we'll we'll go for it. Here's what we need." And yeah, I should say, as pessimistic as I am about congressional action happening at all on any subject, really, this act is a bipartisan sponsored bill in the Senate, the No Fakes Act, and also the House bill, the No AI Fraud Act, which is similar and covers things in much the same way, is also bipartisan, equal number of Democrat and Republican sponsors. So, yeah, maybe my pessimism is misplaced in this instance. So,
Or maybe not. It's right up to, okay, so how many years have we been? joyfully hosting the podcast together
This
since.
is our 15-year anniversary episode.
Woo-hoo!
Yeah. We started in April of 2009, and this is now, well, it's May 1st, but this is technically our April episode for 2024.
15 years.
Congratulations. Happy anniversary.
And happy anniversary to you, because as everyone knows, I'm not the technical genius behind this program.
Well,
So
we have me with my muted mic because I have questions about myself now, too.
15 years. So if we went back to the year number one, we were discussing will the Congress overhaul the Copyright Act?
You're right.
And we've held out no hope, and it hasn't happened.
It's nice
And
to be
so,
right about things, isn't it?
but what we're seeing is, again, as these, it's kind of this whack-a-mole as the issues pop up. And was it last episode or the prior one? It's been since the first of 2024 that, the congressional reviews related to non-fungible tokens came out and said, we don't need to update any laws related to NFTs. So,
Right.
we're having these hearings on AI. Are the current federal laws sufficient to deal with AI? I guess that's really the question that's got to be answered. And if it's not, then will Congress act by enacting a law that they believe is sufficient to deal with AI?
Well,
So,
that is the big question, is it? I'm
yeah.
not going to. Well, I've expressed my point of view, the pessimism that I was talking about.
Well, 15 years. We've been talking
Yeah.
15 years about the Copyright Act having a major overhaul. And neither one of us have the bandwidth to go back to listen for all of our predictions on that
Right.
point. But I feel like at some point I said, within 10 years, we'll have a major overhaul.
Maybe. Yeah, it didn't
I was
happen.
wrong. It didn't happen. It didn't happen.
And I think we do need it at some point. And, it's just a matter of having a system in Washington that works and that isn't just about the political posturing and setting up the table for the next big election and positioning. I don't know. I'm not going to get too political here, but anyway. Let's talk about this 10th Circuit decision involving, it's interpreting and applying the Warhol Foundation for the Visual Arts versus Goldsmith case. The Supreme Court's decision has now reshaped the landscape in copyright law, particularly fair use and transformative use doctrine. This case is White Monkey Productions, LLC, Timothy Seppi versus Netflix and Royal Good Productions. Seppi is a former videography at the Gerald Wayne Interactive Zoological Park. He recorded a video of Joe Exotic delivering a eulogy. Joe Exotic from the Netflix TV show Tiger King. And that video was live streamed on the Joe Exotic TV YouTube page and then stayed there after the funeral for a while. Netflix featured a clip from the video in a segment of the Tiger King show that was about 1 minute and 6 seconds long. That video was taken after Seppi had terminated his relationship with the park, and thus it was determined not to be a work made for hire. So Seppi is the owner of the copyright and the footage. The district court initially ruled in Netflix's favor, looked at fair use, and then the circuit court took a look and disagreed by applying the fair use, the 4 factors outlined in the Copyright Act. First off, the purpose and character of the use. The circuit court rejected the notion that the use was transformative, focusing on the commentary that did not critically engage with Seppi's work, but rather focused on Joe Exotic. And the court said defendants used the funeral video to illustrate Mr. Exotic's purported megalomania, easy for me to say, purported megalomania even in the face of tragedy. And by doing so, defendants were providing a historical reference point in Exotic's life and commenting on his showmanship. However, defendants' use did not comment on Mr. Seppi's video, that is, being its creative decisions or intended meaning. Warhol has deemed such a use to not be sufficiently transformative. So this departure from the Campbell versus Acuff Rose music case highlights a shift towards a stricter interpretation of transformative use. Secondly, the court acknowledged that the nature of the copyrighted work favored the defendants, as the video was factual and previously published. And third, on the amount and substantiality prong, the portion taken was insubstantial relative to the work as a whole, and that also went in the defendant's favor. And on the fourth factor, the effect of the use on the potential market, circuit court found that the district court, the appeals court found the district court's analysis lacking, emphasizing the defendant's burden to demonstrate minimal market impact, again signaling a stricter standard for fair use determinations, ultimately reversed the district court's ruling and remanded for further look at the fair use factors. That fourth one gets me.
Mm-hmm.
I'm not sure it's a wrong decision overall, but is it really the defendant's burden to prove minimal market impact? Well, yeah, I guess it is on a defense. The fair use is a defense,
Right.
so you have to prove, no significant market impact. Okay, fair enough.
So we probably will see this again unless they reach a settlement. I mean,
Yeah.
they kicked it back down, but this is where I was mentioned earlier. This begins to feel like that parity standard of it
Mhm.
must comment on the underlying work to be able to fit within this fair use factor.
But I don't, and I
And
don't,
the transformation factor.
yeah, and I don't think, well, I know that's not what the Warhol case said. The Warhol case looked at whether or not they were created for essentially the same purpose, magazine
Purpose.
illustration.
Purpose and character, but it does transformation fall under the factor, that purpose and character factor, even though, again, in the last 15 years, we've discussed a
Well,
whole lot that transformation has kind of become the fifth factor.
well, that's the way the Supreme Court characterized it, as tying into that first factor in particular, right? But it's funny, I was teaching fair use in my class the other day, and it sort of dawned on me that the first and second factors, the purpose and character of the alleged infringing use and the nature of the original, I find myself wondering, did they characterize it as nature of the original just so they weren't also saying versus the purpose and character of the original?
I don't
Because
know.
if you look at the way it seems to be going, maybe that's really the point, is let's just say it differently so we're not conflating the two, but ultimately whether it's transformative is comparing the purpose of the original versus what the purpose of the new.
Well, I think that is what is happening
Yeah.
in transformation.
So
How close are you stepping? How close is the new work
yeah, if they're
stepping
the same
into the
purpose,
path and purpose of the previous work?
yeah. So maybe it's not really a fourth factor, a four factor. It's really three factors. But how
We
close are the two?
merged the
Yeah.
first two and added this transformation layer into
And
them.
I guess some of the deeper thinking copyright scholars would maybe go back to look at the opinions from the 40s and 50s that dealt with fair use. What was that, Learned Hand and that group of
I
jurists?
love Judge Learned Hand. I
Yeah,
mean, who couldn't love somebody named Learned Hand? That's a judge.
yeah,
So,
right. I missed
and
the
non
opportunity. I could have
lawyers
named one of my
listening
kids
think,
Learned.
yeah, and non lawyers think we're making up that name, but we're not.
He was the grandfather of Mr. Hand from Fast Times at Ridgemont High.
Could be.
No, Mr. Spicoli, it's our time.
Digress down the rabbit trail. I've been working on genealogy, and
Mm.
you know, we have a lot of names beyond Learned Hand that are
Oh,
good
yeah.
Southern names in my genealogy, but we won't go down that path. So
A topic for another day.
that's right. Everybody does as you go down your genealogy.
Yeah.
So
Well, you may remember 6 months or so ago, artists Sam Smith and Normani had sued and won a case over their hit "Dancing with a Stranger," and now their case, they have had some not so great luck on the attorney's fees side of things. A federal judge has denied their request for an award covering their legal expenses. The Stars claimed that that was more than $700,000. And here in the Central District of California, Judge Sue has dismissed that part of the case. He determined on March 18th that the case itself wasn't so devoid of merit as to necessitate penalizing the plaintiffs with payment of the substantial legal fees. Smith and Normani contended that they shouldn't be held responsible for hefty expenses they had to incur in defending against what they deemed a frivolous and unreasonable lawsuit. I'm sorry, so I had the facts wrong. They didn't sue. They were sued for infringement, and they won, and then asked for their attorney's fees. And they said, look, it was merely a gamble by the plaintiffs, hoping for a significant payout, and the judge disagreed, saying no, there was no evidence of a malicious intent by the plaintiffs. And so the plaintiffs in that case, songwriters Jordan Vincent, Christopher Miranda, and Roscoe Banlai, claimed that dancing bore a striking resemblance to their 2015 track of the same name. So they had pointed at the hook and chorus of both songs being similar, as well as the title. And ultimately, in September, the summary judgment motion was granted, and but the judge said no. There was a plausible case there, so no attorney's fees for you. So
yeah, and the defendants went back and said, yeah, but Judge, you said all these things in your decision that would make us think
yeah,
this wasn't a plausible claim, and it was frivolous, as far as the judge pointing out prior art that, quote, contains nearly 20 references to the term dancing with a stranger.
mm-hmm.
I don't know. Even the judge saying the arguments had generic reasoning and ruling in favor of a much smaller recovery of legal cost.
Yeah,
So they did get their cost, but well, I don't know,
yeah,
$10,000, I think,
yeah,
for cost versus 700,000 on the plaintiff side. And this is just me speculating.
mm-hmm.
Is this a potential commentary on, even as a defendant, we need to get our legal fees reined in defending a case?
Well, I mean, it sounds like it. I mean, it'll be interesting to see if there's an appeal here. I think the standard of review for these kinds of things would be abuse of discretion, right? So,
So that's going to be tough.
and it sounds like the judge, made his reasoning pretty clear in the
Right.
ruling. No evidence of malicious intent. It wasn't frivolous and unreasonable. So hard to say. But what does that $700,000 represent? It represents what, a couple of thousand hours of lawyers' work to defend to a summary judgment ruling. So no trial happening, no appeal yet, or anything like that. So that does seem like a lot of money. I think that's something that defendants do need to be mindful about.
Mindful of.
Yeah.
Yeah.
On the
And
other
I'm
hand,
trying to remember, and I feel like I just read this yesterday, and sorry, too much allergy medicine, I guess. Another case where the recovery, and I think it was the plaintiffs actually prevailed and didn't get their attorney's fees. They just
yeah.
got their cost. And the judge going through a similar analysis
I,
there.
I think, yeah, I mean, I think from a public policy perspective, there's something here to the notion that, a ruling like this kind of stimulates settlement. I mean, they could have gotten out of the lawsuit for $150,000 if they lost the lawsuit with intentional willful infringement. The damages would have been in that, well, unless there's actual damages, but statutory damages of 150 grand. So does that mean that you get sued and it's cheaper to offer a settlement than to defend, even though it's a frivolous case? This is bogus. Come on, it's ridiculous. So public policy, maybe, I don't know.
Yeah, mediators in this area may start to pursue that. I still struggle with dismissals on copyright claims on motion for summary judgment, even though I know it can.
Yeah. Well, I mean, I guess if you have the experts lining up and saying, no, they're really not that similar.
Yeah, and sorry, I wish I had made that. As I'm looking at my notes, I didn't write that case down, because that case that I was reading that we had discussed in an earlier episode actually did hinge on the experts.
Yeah.
And making the ruling at the motion for summary judgment. So,
well, the question is material issue of triable fact. And if the experts are sort of lining up saying, well, it's not really that similar, then it's asking the judge to just interpret what does that mean in terms of infringement or any of the other elements of the case, I guess. But yeah, it's $700,000. I mean, the defense cost them more than they would have had to pay in the. Well, their profits would have been the issue in that case, wouldn't it?
Right.
So
I think so. I
yeah.
think so.
Eh,
And then we don't want to set that up for every time. Oh, just sue me and I'll pay you the
yeah. So
statutory damages. No.
maybe another area for the overhaul of copyright statute to address the defendant's right to attorney's fees.
Okay, so I do want to just correct myself
Mm,
as far as changes to the Copyright Act in the last 15 years. We
okay.
have had one major change,
Yeah.
the small claims court.
Right.
Now, I think hopefully they'll issue another report as to how effectively it's working,
Right.
but
Should
it
we take
just
credit for that since we were talking about it in the past 15?
we will take credit for all successes.
Let's wait and
Failures,
see if it's actually working well.
nothing for us to deal with. But yeah, so I look, and again, one of these things that made me think about it is we're talking about attorneys' fees
Yeah.
and damages because, had this gone through the small claims court that was from the Case Act,
Mm-hmm.
damages would have been capped at a much lower amount of money. But clearly, these
Well, here we had a
songwriters
hit
felt their
recording.
damages
Yeah.
exceeded that. So.
Yeah. And, so they gambled and lost, but at least they didn't have to pay out the attorney's fees to the other side. So
Right.
I guess that's sort of the cost of doing business when you're a big star with big famous records and things. But
Deep pockets.
yeah, well, it would be interesting to know how much did the artists actually collect in their share of record royalties from these albums after recoupment of recording costs and marketing and all that stuff, whether or not they're actually now losing money on the song or not.
Mm.
But
That's conversation for another day.
exactly. Well, we have one more message or story to share with folks, and it's been big news in many business arenas these days. That is the Federal Trade Commission's non-compete ban that was announced on April 23rd. The FTC has made this rule, and it's actually a 570-page PDF document to make a rule that really only needs 10 pages or so or less in the Code of Federal Regulations. So I was amused because as I was scrolling through these 570 pages, I landed on one of the pages that was the heading was Federal Paperwork Reduction Act notice.
Well, you did better than I did. I did not even scroll through. You know what? While I'm watching the 2-hour hearing,
Yeah.
I'll multitask and
Well,
scroll
I'll help
through
you
the
out.
500 pages.
Yeah. Well, what I'll do is I'll tell you the first 561 pages are prefatory material explaining. And look, it's legislative history stuff, so it has its relevance here and there. But the text of the actual rule starts on page 561 of this 570-page document. And what the law does, or the rule, when it goes into effect, they have to project that forward about 120 days after publication in the Federal Register for it to be a Federal Register, Federal Register, before it becomes a part of the Code of Federal Regulations. But it adds subchapter J to Title 16 of the CFR, starting at section 910. Now, non-competes have been illegal and unenforceable in California for, a century and a half.
Oh, wow.
So a long time.
I thought it was the whole 7-year thing in California.
Well, there's a 7-year statute on binding personal service contracts. But in an employment contract, you can't tell the employee, hey, after you're done here, you can't go work for our competitors.
Okay. Because the law has been revolving and evolving in Texas, and obviously very, very narrow in scope.
Yeah.
And so I actually kind of love it when I see prior to this, but when you would see an employment agreement come across that had this just egregious 10-year non-compete, and I'm like, let me just tell you, let's don't negotiate this because it's never going to be enforceable. So let's get everything else we want and just no, though they can never enforce that.
Yeah.
They can maybe sue you, but it's not enforceable. So we've talked about the states' rights versus
Hmm.
federal rights, and here is an example of
Yeah.
where the Federal Trade Commission is preempting all state laws related to
Yeah.
non-compete.
Yeah. It has, obviously it does have broad authority over interstate commerce and labor and employment areas, although states also have labor and employment law in effect. So this is interesting. Um, and it's not gone without challenge, but what the law will do is essentially prohibit the use of these non-compete clauses in employment agreements. It's a retroactive ban, which means any existing non-competes will be
Mm.
invalid from the moment the law takes effect. And there are just a few small exceptions. Senior executives with non-competes, those will remain in effect, but no new non-compete clauses for senior executives. It does not apply to if you're selling your business and promising not to compete against the company you used to own. So that's still a valid
That makes
restriction.
sense.
Yeah.
Yeah.
And it doesn't apply to certain kinds of banks and healthcare businesses and stockyards. So interesting healthcare businesses, because that's one of the areas that I see a lot of, or I hear about a lot of non-competes in other states is doctors agreeing not to compete
Right.
against their former practice when they move to a new practice and things like that. But the consequences, this is what's interesting. The FTC is actually going to impose fines, penalties, and injunctive relief on employers that continue or try to use these non-compete clauses. And look, it's already a non-enforceable provision, and it might even render an entire contract void if it's not handled correctly. So the fines and penalties is pretty significant. The federal government's going to come after you and say, wagging your finger, okay, pay up, you used one of these clauses. You pulled out an old contract form from a file somewhere and oops, now you pay a fine.
Right.
So companies have to pay attention to this. It also requires that employees who are currently bound under an existing non-compete must be given notice of this change before the rule takes effect. And it actually includes the
I need to make a
specific
note
language.
there.
Yeah. Uh, it
Practice
actually
pointer for
includes
your
the
client.
specific language of the notice. So there's just a model notice. Hey, the government has changed the rules. This no longer applies. So you're advised. And one of the interesting things that I've noticed is it doesn't have an impact on trade secret law. So if you have an NDA, that's still in effect. And a lot of NDAs really have the practical effect of preventing you from going and working from your competitors because you take the knowledge you gain on the job with you. And so competitors will still be maybe reluctant to hire people who worked for the other company, because they'll get sued for the trade
Right.
secret
And I
violation.
think that's something, this is a conversation I often have with my clients who are, maybe they're not quote in the entertainment field,
Yeah.
but they're businesses who create content or whatever their business area
Mhm.
is, where maybe they've got salespeople.
Yeah.
It's like, even if the salesperson is not under a non-compete, under Texas state law, they have a duty not to disclose, this competitive information.
Oh, even
Because
in the absence of a non-disclosure clause?
that's right. You
Oh.
can't under our state common
Mhm.
law, you have a duty of non-disclosure of confidential and proprietary information.
Yeah, I mean, I guess that makes sense. It's proprietary. It's
So
property. Yeah.
that's right. So if I have a method for sales formula or
Mhm.
marketing, you can't go take that to the next employer. Now you can go take your common sense. Nobody's stopping that. I
Right.
always love before I'd even thought about going to law school, my sister, this was when she was in college, went to work at a daycare, and they wanted her to sign a non-compete that she'd never go work for another daycare. So even at 20, she was like, I'm not signing that. So you
Right.
can see at that level, that's a very egregious. You've got a
Yeah.
hourly wage person,
Mhm.
uh, non-enforceable. So here's what's
Yeah.
interesting on these estimates.
Mhm.
The FTC says that putting this ban in place is going to mean more innovation, an
Mhm.
average of 17,000 to 29,000 more patents each year. I don't know how they're coming up with
Hmm.
that, but I guess they think individuals will be more likely to pursue a patent, but yet,
Well, that's
or the
interesting.
companies, I don't know, because if you're employed to, and we aren't patent lawyers. I'll put
Yeah.
that disclaimer in for both of us.
Mhm.
But typically, the inventor and the employer are listed on the patent
Yeah.
application. So, not sure how that number
Well, I guess
came
what
about.
they're anticipating would be people leaving their employment and then patenting something they, in their own name as an independent. But if you, that's where the NDAs come in also. If you developed something partly while you were working for a company and then you use it for your own benefit, isn't that a violation of NDA language as
I
well?
don't
Yeah.
know.
So, but interesting.
It also says 2.7 increase in new formation of startups. And this probably ties into exactly what
Yeah.
you're saying. The person says, gosh, I'm going to leave and go start this new
Hmm.
business because this is my idea and I'm going to
Hmm.
implement it after
Or
the
I've
fact.
developed this amazing skill set that I can use as a consultant privately and provide the same thing to 12 different companies.
Uh,
You know.
Higher earnings. This was interesting.
Mm.
Typical workers earn $524 more annually.
I can see I can see that with greater mobility of employees, because now I can go work for a competitor, the company wants to keep me, they're maybe willing to pay me more.
Yeah, that's true.
Yeah.
That's true. And it's interesting. You and I talked about before we added this to
Hmm.
the
Hmm.
rundown. So we want to give a hat tip to Michael Glazer, right? Michael's the one that kind of sent us
Yes.
this.
I think he goes by
Thank you,
Mickey. Yeah.
Michael. Sorry.
Yeah.
Um, hey, how does this kind of apply?
Hmm.
And I think it really is just good information for us to have as
Yeah.
we advise individuals, small businesses, larger businesses who,
Hmm.
as you mentioned, this has a retroactive effect
Yeah.
that people may be subject to one of these, that it's going to go away, or the
Hmm.
business has maybe operating with the thought that these are going to be enforceable forever, or at least for the term that was drafted in the original signed document. And
Yeah.
now we need to be giving them a heads up that's not going to be the case any longer,
Yeah.
or at
I
least
mean,
connecting them with employment law attorneys that can advise them appropriately on what to do next.
yeah, and it's important to remember that even though California seems to be the hub, or at least a hub of the entertainment industry, there are plenty of entertainment businesses outside the state of
Yeah,
California
tech
and Texas
businesses.
where they have used non-disclosures with writers and designers and computer programmers and folks like that that had that non-compete language in their contracts. So now those folks are a little more mobile in their employment prospects and can start competing companies and things. So I don't know if it's going to really change. I mean, being in California, I've always sort of taken the view that non-competes are disfavored and I'm not going to go for it. Although I have in a few instances just said, well, you live in California, you're working in California, they're never going to be able to enforce that. Now it's nice to be able to say that sort of at a more global level.
Right, along my lines of it's a 10-year non-compete and you're at this level,
Hmm.
it's not going to happen. It's just going to be unenforceable. So,
So back to my political pessimism for a moment, I do have to ask, does this FTC rule survive if Mr. Trump becomes the president again? Or does that new administration come in and say, no, 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 put that away, take that away? Can they undo the regulation as
can
fast
they
as we thought?
undo that? Gosh, I don't know the answer to that.
Mm.
I may be thinking along the lines of, if Mr. Trump becomes President Trump once again, that he's leans toward supporting the business world.
Yeah.
Would he
So
would
does
he
this
see
become a
that
political
as, this is
football?
not
Yeah.
right? Is this not beneficial to businesses, and as such, we need to remove it?
Yeah.
I don't know.
Yeah. Be interesting to
I don't know.
watch.
Yeah, we will
May we
see.
live in interesting times. Isn't that the famous curse?
That's exactly right. It's always an
Yeah.
interesting time. So while I often wish I had been a child of this, a teenager of the '60s,
Hmm.
there's a part of me that's kind of glad I wasn't a teenager of the '60s.
Well, if you take a look at what's going on around college campuses right now, it's looking a little bit like the 60s, isn't it?
It's looking a little bit like us reading. Yeah, I've been comparing it to, I wasn't old enough to understand all of that happening around the Vietnam War, and
Hmm.
now I'm trying to wrap my head around what's happening right now. So
Yeah.
I need to have this conversation with someone who was a college student.
Yeah. Well, I was
It's
talking to
very,
my students earlier this week,
yeah,
and we're at a very small arts college, with a very small student body, and they're not having these conversations. They're just, no, I've got more to think about than this. But then at UCLA yesterday we had violence, and
yeah, yeah.
so
It's a little bit like I have had this conversation with my mother during. She had small children at home during the Vietnam War, and
hmm
she also had a brother who was in the Vietnam War.
yeah,
She's like, I was so busy raising my kids and living, that
hmm
life that she just wasn't as aware and tuned in. And obviously,
yeah,
yes, the Vietnam War triggered so much being more available on the
hmm
news. But again, I think it is the best comparison
yeah,
analogy we have as to what's
mhm,
happened on campus then to what's happening now.
yeah, and the civil rights movement. There's,
And the civil rights
yeah.
movement,
So
obviously, yes, yes.
anyway, well, on
We
that
we we,
bright
we
note.
cover lots of things.
Yeah. Anyway, that is it for our episode this month. Entertainment Law Update is, again, we want to say thank you to all of you, our listeners, for spending your time with us, and to our sponsor, JD Supra, the leading platform in professional services content marketing to help lawyers turn their expertise into networking opportunities, media visibility, and new business. Go to find more information about JD Supra by visiting resources.jdsupra.com. And of course, if you have feedback for us, and we welcome it, thanks again to Mickey Glazer.
Mickey, I'm sorry.
No,
Mickey,
it's
I said
Michael, but I
Mike.
think he goes by Mickey, so we were both
Yeah.
right. And we'd love it if you would share your thoughts with us. We have a voice widget. If you would like to hear your voice on the show, you can go to entertainmentlawupdate.com and just tick on the little red tab over on the right side, I think it is. Or you can send us email, entertainmentlawupdate@gmail.com. You can find us on the X service known as Twitter, now known as X. That's Ent Law Update is our handle there. And Tamara, how can folks reach you directly?
Yeah, you can find me, my website, tbennettlaw.com or createprotect.com. Both of those will take you to the same spot.
Mm-hmm.
So if we've been doing 15 years of podcasting, then I think I've probably got 17 years of blogging.
Mm,
So just think Create Protect takes you to that.
right.
So social media, most sites I'm at Tamera Bennett, TamerABennett. So Gordon, thank you so much for always including me and for a great 15 years
Yeah.
as we have moved and adjusted with the technology and the times and
Yes, indeed. Thank
pulling
you.
me into 2024 with video.
Yeah. And yeah, for those of you who are listening on audio, you now can also find us on YouTube. We are a YouTube video podcast. You can head on over there and find us. It's under my personal social YouTube account, G Firemark, but the playlist is there as Entertainment Law Update, and we'd love it if you'd check that out.
Yeah.
You can find me.
And on JD, I was just going to say,
Oh, right.
for the last 6 months, our both audio and video, depending on what we put out that
Yes,
month, are
indeed.
available at JD Supra for your
Yeah.
pleasure of viewing and
Yeah.
listening.
Yeah, and so I'm G Firemark on most social media. My website is firemark.com. The email address is gfiremark@firemark.com. And let's give a shout out to our crack team of volunteer contributors, managing editor John Janasek, who has been with us for a good chunk of that 15 years. We love it, John. Thank you for being a part of it. Charles Thorne, Mark Lindeman, Alexis Allen, and Violet Zhang also contributed to this episode. And if you are interested in joining the fun as part of our team, our family of contributors, please reach out at entertainmentlawupdate@gmail.com. And with that, I will click the button to play the music and say that wraps up this episode of Entertainment Law Update. Thanks again for listening. And until next time, that's showbiz.